All right. Good morning, ladies and gentlemen. Welcome back to day 2 of the Law 2.0 and Money 2.0 conferences, powered by Weekly Real Estate News. I hope you all had a wonderful first day yesterday at the conference. Now, again, let's keep those hashtags rolling. Remember, those are law, the number 2, CONF, and also money, the number 2, CONF. And remember to just tag us in any of your tweets, stories, and posts. Again, we're on all of your social media platforms, Instagram, LinkedIn, Facebook, all of the above. Now, before starting the first session, I would like to extend my gratitude to our title sponsor, Weekly Real Estate News, and our silver sponsors, Mindful Media PR, as well as Swan Virtual Family Office. Now, without taking any more of your time, I would like to begin our first session of the day. This panel discussion will examine some of the most important cutting-edge and complex issues around data protection, with a focus on how to protect client data and keep pace with global privacy laws. The panelists will cover everything from GDPR to blockchains. Get ready to listen to the views of these leaders on protecting client data and keeping pace with state, national, and international privacy laws. Please welcome the panelists, Paul Lanois, Director of Fieldfisher, Katharine Perekslis, Vice President at eDiscovery Services at TransPerfect Legal Solutions, David Cohen, Partner and Records and eDiscovery Practice Group Leader at Reed Smith LLP, Mr. Mark Foster, founder of law offices of Mark Foster, and Mr. John Thaler, attorney at Harris Thaler Law Corporation. Let's welcome the moderator of this session to take us through the next discussion. Thank you, guys.
Good morning. Welcome to day 2, everyone. Welcome to our panel on protecting client data and keeping pace with state, national, and international privacy laws. I'm joined today by data privacy and legal professionals who all deal with challenges regarding keeping their clients' data safe in their daily work. And we're going to walk through some of those challenges as they relate to data security and navigating the ever-changing landscape of state, national, and international privacy laws. Of course, we only have 50 minutes, so we're not going to possibly be able to hit every single privacy law that is in existence, but we're going to hope to get to a high-level overview and hopefully have a few minutes at the end to have any questions from the audience. My name is Katie Perekslis. I am the Vice President of eDiscovery at TransPerfect Legal Solutions, or TLS. We are a legal services provider. I am a technologist. I am not a lawyer, but I've been working in eDiscovery for the past 13 years, and I oversee a global team of 150 eDiscovery project managers and consultants across the globe in London, Europe, the United States, Canada, Hong Kong, mainland China, and Australia. So I deal frequently with advising clients on international data privacy best practices using technology solutions. Now I'd like to turn it over to the other panelists to introduce themselves. Mark, would you like to go first?
Okay. Mark Foster, law offices of Mark Foster. We've been in Silicon Valley for more than 35 years with a couple of stints in Japan when I was special counsel to the U.S. Embassy as a trade lawyer there. We're basically a high technology oriented law firm. We have a global set of clients, mostly focusing on the technologies and in particular on the medical technologies. And my comments today will be arising from my practice with medical technology companies. Thank you.
Great, thank you. David, would you like to go next, please?
Sure. My name is David Cohen, and I'm a partner at the international firm Reed Smith. We're a global law firm with about 30 offices throughout the world, and we have big eDiscovery groups in the US, which I manage, and in Europe, well, actually in the UK. And we have a technology subsidiary with about 45 eDiscovery professionals. So we deal with a lot of data, millions and millions of documents per year. But I head up the records and eDiscovery practice. So in addition to doing eDiscovery, where we have to protect client data, On the record side, I also advise clients about information governance and what they have to do to protect their data and comply with all these new crazy privacy laws which have come out and are continuing to come out.
Great. And John, would you like to introduce yourself and kick us off?
Hi,
Paul, sorry, I missed you.
Sure. Hi, everyone. My name is Paul Lanois. I am a director at the European law firm Fieldfisher, and I advise clients in relation to privacy, data protection, and cybersecurity law. I work in the Silicon Valley office of Fieldfisher, and before coming to the Silicon Valley and before actually coming to the US, I used to be working internationally. I was vice president and senior legal counsel at Credit Suisse, where I was based at the bank's headquarters in Zurich. I also spent a couple of months at the bank's Hong Kong office. Before that, I worked at law firms in France, in the UK, and in Luxembourg. So for me, the topic of international privacy, cross-border data transfers, and so forth, those are topics which resonate very well with me because I have worked on those topics for many, many years now.
Great. Thank you. And John, would you like to go?
Hi, I'm John Thaler. I've been practicing law for about 32 years, and over the 32 years, I have conducted extensive investigations into fraud, racketeering, and other traditional white-collar crimes. That could also be embezzlement and bribery, public corruption. I'm also kind of, you might say, the guy who takes the bullet. In my most recent investigation, which is of the state of Arizona and specifically Maricopa County, I've had at least 6 attempts made on my life, 3 in the last year alone, which is why I'm here and not there. The best I can tell you is, and I'll speak about this in just a moment, is you're really not protected. And what you really have to deal with is not the idea that Norton or McAfee or some other antivirus program is going to protect your data, but what can you do to make it harder for people to intercept your data? And that's what I will be speaking on. I'm glad to be here, and I gotta tell you, I am glad to be here with these panelists. If you have questions, certainly afterwards, come see me, come see them. These guys are the best that there is.
Thank you so much. I'm actually going to let you start off telling us a little bit about what we should be doing to protect client data and why it's important.
Well, let me talk about this a little bit. The State Bar of California, the State Bar of Arizona, the State Bar of New Mexico, the State Bar of Colorado, all have one interesting thing in common other than being state bars. All of them have phantom lawyers in their system. That's how bad this situation is. If state bars can be hacked, you can be hacked. So don't think for a moment that simply having Joe the IT guy come in and set up firewalls is going to protect you. It won't. In the investigation that I've been doing in Arizona, we have hacks into the Maricopa County database, into the city databases. That means data can be put in to make somebody a criminal who was never a criminal, to charge somebody who didn't commit a crime, to take away information from somebody who committed a crime but is valuable to the organization that wants to take away that information. Whatever you do, you have to understand that if you have data, it's going to be hacked, and it's going to be hacked time and time again. California now has created a reporting requirement, and this is what's gone on in a number of states now, that says that if you get hacked, if your data is exposed, you must now report it to the state. And that means you're going to be exposed for this. That means you have potential liability for this. It means that you better make sure that any malpractice insurance or general liability insurance you have covers this. Okay? I don't have any great recommendations to this other than to say that when you bring in an IT person, make sure you run a background check. Most hackings are not done strictly from the outside. Most hackings of valuable data. Now, not somebody who's just trying to get a bank account or trying to get a credit card, but somebody who's trying to get valuable data is going to do so usually from the inside out, which means the program that was installed has a trap door to it. It means that your IT guy is getting paid off some money to let someone else get into the system. That's the most important thing. It starts with who you hire. Make sure you run background checks on them. Make sure you know the company. Make sure you know these people. That means even checking criminal records if you have to. But don't let this go, because the liabilities that you're going to face for this are going to be huge. The other panelists are going to talk about data protection, which is once you have it or once you have to give it up, or as Katharine does, once you're trying to discover it, then there's different issues that apply. because then you have to actually give up data. And how do you protect some data versus others? But if you don't have your data locked up, I guarantee you at some point it's going to be hacked, and you'll never know it, because clients will wind up, kind of randomly. If you have 100 clients, 10 of them will have their social security information stolen, their birth dates stolen, their addresses stolen, even the name of their dog. I'll leave you with this. If you want to know the best place to hack information, it's actually from dating websites. Think about dating websites. It doesn't matter if you're in a serious site like eHarmony, which is probably even worse, or if you're doing Tinder. Think about the information that you put on these sites. Imagine what happens, and we had this years ago with the Ashley Madison incident, where somebody came in, hacked out Ashley Madison's databases, then went back to the people who were on the site and blackmailed them for a couple $1,000s each, saying, we're going to tell your family members what you've been doing if you don't pay us. And the fact of it was, they could even mention things about you and your family. We know who you are. We know where you work. We know how old you are. We know your birthday. Pay us $2,500 or we'll expose this information. For the most part, nobody ever did, but that's the best place to steal data. So also, when you're putting in your client's data, consider what data needs to actually go in a database. People aren't going to hack written documents. They're not going to hack your notes, but they will hack what you put in your database. And if you put all that information on a singular database, I don't care how secure you think it is, it's going to get hacked and it's going to get out there, and then you're going to be reporting it, and then you're going to have lawsuits. Very important to consider. Thanks.
Thank you. That's very insightful and very terrifying. So I'm happy to say that I'm not on a dating website, but okay, that's great. So I'm going to actually turn over my podium now to Mark to talk a little bit about one of the important data privacy protections we have here on a national level in the United States, and that is the HIPAA regulation.
Okay, thank you. So I'm going to speak just for a moment about HIPAA, the Health Insurance Portability and Privacy Act. So the immediate reaction most of us will have is, oh, don't worry, I'm not a doctor's office, I'm not a dentist's office, I'm not a hospital, I'm not a medical provider, I'm going to go to the next seminar. But you might be, and this is why I'm raising this, you might well be, or your client might well be a business associate, and that's where most of the liability that is unaddressed arises. So before we get too far, everyone's aware of HIPAA, right? You get those messages and you get those notices every time you go to the doctor. So there are, I think, 18,000 pages of regulations that have been drafted that relate to HIPAA at this point. The upshot of HIPAA is that if you're not a hospital, a doctor's office, or a direct medical office's provider, you need to determine whether somebody in your firm, including law firms, including IT firms, including HR consultancies, is a business associate or is indirectly under the jurisdiction of the HIPAA laws. I'm tempted to say there's a magic bullet. It's not exactly a complete magic bullet, but if your organization, if you believe that your organization is a supplier or a contractor to a company that does itself have HIPAA compliance requirements, you want to look very carefully at a BAA, a Business Associates Agreement. Under HIPAA, if you sign a Business Associates Agreement, let's say you're the IT guy that was just mentioned, and her company, and you're doing work for dentist's office, you want to probably look very carefully at signing a Business Associates Agreement that you will give to the companies that you're working for that are themselves directly controlled or regulated by HIPAA. A Business Associates Agreement is essentially saying an undertaking, a unilateral undertaking, saying that we're aware, we've studied, we've gone to a seminar, you can go to It's a web-based 2-hour seminars, and you can, answer the question at the end of the seminars, and then that's what you need to know about HIPAA, and then you can sign a HIPAA business associates agreement saying, yes, I understand what HIPAA is. I may well be subject to HIPAA, and I've signed a business associates agreement. So here, dentist's office is my BAA. Keep that in your records. Now, there is no official recognition of your business associates agreement, so it's a self-declaration, a self-certification, but it does and it can come up in litigation. In my experience, we don't do litigation, but we certainly do find we find our companies involved in litigation, and this kind of thing does come up quite regularly in litigation as to whether HIPAA has been complied with or not. So if you have any questions about that, another key thing is the apps. There wasn't a good way to display this, but I have put together a non-exclusive but pretty extensive list of which apps are HIPAA compliant, and if you'd like that, reach out to me and I'll email that to you. Thank you.
Thank you very much, Mark. So we're going to move on to talk a little bit about moving away from the national data privacy regulation, but more into a state privacy regulation, and I'm going to turn it over to Paul.
To me first, okay. So in relation to the different national privacy laws, I'm sure most of you have heard about the California Consumer Privacy Act, which is the current legislation applicable in California. And this California legislation introduces quite a number of privacy rights which already existed in the EU. You have, for example, the right of access, the right to know what information has been collected about you, the right to access as well the information which was collected about you. You have the right to delete information as well. And so you do have a range of different privacy rights which were recognized by the CCPA, the California Consumer Privacy Act. And this is going to be expanded as well in the next month, actually. So you have, from January 1st onwards, you have the CPRA, the California Privacy Rights Act, which will enter into force. And the CPRA would extend the existing California protection. You have new privacy rights, for example, the right of correction, which would apply. You have as well a number of additional disclosures which are required under California law. For example, if an organization collects sensitive personal information, that will need to be disclosed as well in the privacy notice. Importantly as well, what is considered sensitive personal information under California law goes well beyond the GDPR, because it also includes in the definition certain types of data that virtually every online organization collects, because if you have, for example, the login along with the associated password, that is considered sensitive personal information under California law. So this is something to be mindful of. You may have to update your privacy notice to accommodate the new privacy requirements. Another big concept under California law would be the selling of information. So if you sell information as defined under California law, you will need to disclose that, and you will need to provide consumers with the right to opt out. Now, the definition of sale under California law is very extensive. It doesn't just include the exchange of information against money. Basically, as long as there is some kind of benefit, that would be considered a sale of information. And we have seen as well over the past couple of months a number of enforcement actions which have taken place in California. You have the Office of the Attorney General in California, who has sent out quite a number of enforcement notices to companies, telling them that they need to disclose, first of all, if they are sharing information, and if so, they need to provide the opt-out link. And you do have as well this big case which came out in August. You have this big settlement whereby Sephora had to pay $1.2 million as penalty because it did not disclose that it was providing information to analytics and for advertising purposes, and it did not provide users with the capability to opt out of the sale of information. And as though that was not enough, the CPRA, which I mentioned, which will enter into force in January, that would also further extend what is required, because now they've introduced as well this concept of sharing of personal information, which would be subject to the same limitations as the sale of information. So under California law, the sharing of information would be whenever you disclose information for advertising purposes, that would be considered the sharing of information, in which case you need to provide individuals with the right to opt out. Now, some of you may be thinking, well, opt out, that's easy. We can just provide a cookie banner and, we can just say, well, you can just opt out of that. But then you have the regulations which came out as well from the newly created California the California Privacy Protection Agency, which indicate in the regulations that, well, providing the cookie banner is not enough, because that doesn't cover what you have in mind. So you have to bear in mind not only the collection of data, but also the subsequent transfer or disclosure of information, which needs to be restricted. So those are the at a very high level, those are the key requirements that you have under California law. In addition to what I said, well, you have other privacy laws which will come into effect during the course of 2023. You have, on the 1st of January, you have Virginia, which will have its own privacy law, which will enter into effect at the same time as the CPRA. And then in July, you would have Colorado and Connecticut. And then in December, you would have Utah. And while those laws are not identical, of course, they do have the same principles. They do have the same underlying requirements. And of course, if your organization is doing business in the United States, well, you would have to comply with the requirements of those states. So that's what I wanted to mention at a very high level, given the limited time. But then, of course, if you have any questions, feel free to let me know.
Great, thank you so much. So moving on to international privacy laws, before data privacy was a hot topic here in the United States, European Union had already enacted a major data privacy regulation, the General Data Privacy Regulation, or normally known as the GDPR. This addresses data protection and privacy both in the EU and the European Economic Area. This law is often looked at as the models for the others that have come after it, such as the CCPA that Paul was just speaking about. And one of the key factors about the GDPR is that it has an incredibly broad definition of what constitutes personal data. So everything from what you would expect, like credit cards and date of birth, all the way down to something as simple as a business email address or even a job title, if the job title is unique enough to identify a specific individual. So for example, my company only has one CEO and one general counsel. So if you said the CEO of TransPerfect, we would all know you're referring to Phil Shaw, and that title by itself, without Phil's name, is considered personal data. So the definition is really broad. And while we've just started to bring data privacy to the forefront of the US, and we're starting to get more and more state laws and potentially a federal law in the future, it's been a well-established expectation of privacy in Europe by European citizens. So with this broad definition of personal data, every email by default contains personal data, and 95% of your electronic documents do as well. So one of the biggest aspects of the GDPR is that it generally prohibits transferring data outside of the European Union. There are several countries that have been deemed jurisdictions of adequate protection due to them having similar data privacy regulations, including the United Kingdom. However, the United States, with a lack of national privacy law, is, aside from HIPAA, but not protecting non-sensitive personal health data, is certainly not one of them. So in a world where we have a lot of international business and a lot of cross-border business, recognizing that we have legal obligations in the United States to transfer that data to satisfy those legal obligations in the United States, we have to look to what the exceptions are to the GDPR to comply with that. The most relevant exception for the purpose of complying with litigation and investigation needs is where it's necessary for the establishment, exercise, or defense of legal claims in the context of specific administrative, regulatory, or judicial proceedings. But the challenge is getting that data down to what's strictly necessary for transfer. For example, if I have a litigation or I have to respond to a regulator in the United States and I have a particular party involved, I don't need to transfer their entire contents of their email box for the last 3 years to comply with that obligation. I need to first limit that to what's relevant, what's not privileged, what actually has to be produced to satisfy the requirements of that regulatory investigation. So one simple data minimization strategy is to reduce the data, process it and host it and review it in country, in a jurisdiction of adequate protection before transferring it to the United States. You can do that in a couple of different ways. One simple strategy is to do deduplication prioritization. It's likely that if you have a cross-border matter, you also have custodians that are located in the United States. So you can prioritize their data and deduplicate the data coming from the international location against the US data first, so that you're limiting the scope of what actually needs to be transferred. Another strategy is, as I mentioned, to use servers and personnel that are fully located inside of the European Union to minimize that data before transfer, or other jurisdiction that's subject to a data privacy law. It does not have to be necessarily the EU, but since we're talking about the GDPR, that's kind of my focus. Ultimately, it becomes a risk management exercise at which stage it is necessary to transfer the documents. One that is informed by the value of the proceeding in the US or foreign jurisdiction, and also by the nature of the personal data contained in your data set. For example, when dealing with sensitive personal data, such as personal health data like Mark spoke about earlier, there might be more risk than dealing with simple business email addresses. And you might want to take additional steps to redact sensitive PII and PHI prior to transferring the data. Half the battle is identifying where the PII and PHI actually appears in the data set and which documents do not contain PHI or PII and thus do not trigger data privacy concerns and can be transferred without conducting these extra steps. With the proliferation of data volumes in today's world, a manual approach is really not a viable option to conduct this review, but there are some technologies that can unlock substantial time and cost savings. One of these techniques is using regular expressions, which identify patterns in your data, things like national health identification numbers, credit card patterns, date of birth, but these alone are not enough to identify all the potential personal data in your data set. So you might want to also use entity extraction, which finds all of the different people and places that are identified in your data, as well as just constructing some really thoughtful search terms that can identify things like looking for the expression date of birth or DOB, things that you might expect would contain personal data. And then finally, you might want to consider automated or native redaction tools that are available for mass applications of redactions based on the results you find through the regular expressions, entity extractions, and advanced searches to further streamline the redaction process prior to transferring your data to the United States or other jurisdiction for production in your litigation or regulatory proceeding. So we've covered a lot of ground in a fairly short amount of time, and I'd like to make sure that we have a little bit of time for questions from the audience. So I would like to turn it over now to David to draw some conclusions across these topics for us.
Thank you, Katie. So I get to be the cleanup hitter here. Those were all excellent presentations. And I think Katie just gave you a great summary of the GDPR. Just to add a couple of points to that, if that sounded complicated, it's even more complicated. The GDPR runs more than 100 pages long, incredibly difficult. Katie talked about the data transfer restrictions, but even the processing of data in the EU is subject to other restrictions against data processing, and that includes all the filtering. So even to do that in Europe, you first have to do a balancing of the individual rights against the needs of the matter. And in Europe, as many of you probably know, their litigation and dispute resolution is completely different than ours. US has broader discovery of information than any other country in the world. And in the EU, there really is no discovery. So when they learn that we freely trade documents with litigation adversaries, they're shocked. You know, what's wrong with you? You know, this is private information. Totally different mindset. And so it's really been a struggle to try to balance discovery obligations in the US, especially in cross-border cases, against GDPR restrictions and some of the new privacy laws in other countries around the world, such as Brazil and China. We're seeing new laws in India. So there's a lot to watch out for. So one piece of advice that I'm going to leave you with, and by the way, you violate those laws, the penalties are massive. One violation of the GDPR can bring a fine of up to 20 million euro, which is, you know, close to $20 million. It used to be more than $20 million. I think it's getting close for one violation, or 4% of your company's worldwide annual revenue, whichever is greater. That's one violation. So this is serious stuff. And so my best advice to you is, if you get involved in any of that cross-border litigation where you need to bring data across to the US, before you do that, check with knowledgeable counsel, because there's lots of things to comply with. And then my second tip for you is there are some free resources. If you were here yesterday, I mentioned the eDiscovery app. It's a free download on Google Play or the App Store. You can download it to your smartphone. There's a whole section. It has the whole text of the GDPR if you have several hours to get bored reading it. But it also has a checklist for GDPR compliance for US litigation. It also has a form of protective order that you can get entered in US cases. So those are various ways. None of those by themselves, by the way, will get you in full compliance. If you do everything on the checklist, you're getting good, but there's a lot there. So free resource, just search for eDiscovery app on your favorite database. I did want to make just a couple of quick remarks about some of the other things that you heard. I think John's talk was very sobering. I do have to disagree with him about one thing. He said if you join a dating app, then somebody's going to be able to find out your birthday. From what I hear, they really won't. They'll probably find out something that's like 5 or 10 years before your actual birthday, because no one tells the truth on the dating apps about the birthday. But it is very sobering. But what John was talking about was other people stealing your information. But some of the most notorious data breaches, if you look in the last few months, weren't from theft, but from lawyers or legal professionals not understanding how to protect data. And I talked about one example yesterday, the Alex Jones case, where Alex Jones' lawyer inadvertently turned over the full contents of his client's cell phone, including privileged information, personal health information, et cetera, just by mistake. He directed a paralegal to do something, and he didn't realize that the link he was providing had the entire contents of the cell phone. The ultimate result, not just because of that, but because of Alex Jones' misconduct, was verdicts totaling about $1 billion against Alex Jones, who's now filed for bankruptcy after that. But that's one example where it was nobody stealing the data, and there was another example that immediately followed it, which was the January 6th committee you might have read about. The chair of the committee investigating the January 6th incidents sent a link, and it got to the press, and the link was to confidential documents that had been turned over by Donald Trump and his lawyers under order of court, but there was it was unintentional. The council did not want to make all those documents public, but accidentally did by sending a link. So I think both of those cases underline how easy it is in today's world to inadvertently turn over confidential information. Of course, we as attorneys have legal and ethical duties to protect the confidences of our clients. So that requires us to really learn what do we have to do to protect data. So that's the last thing I wanted to talk about a little bit was what should you as a legal professional, or in some cases, I know we have financial professionals in here, what should you be doing to protect that? How did these things happen in the Jones case, in the January 6th case? Well, part of it was this data was not protected. There are things you can do to protect data. You can encrypt data. Best practice is to encrypt sensitive data both at rest and when transferring that data. That way, if somebody does get a link to it, they can't, unless they have the key, they don't know what it is. Password protections. Neither of those sites I just mentioned had password protections. So even if you mistakenly send a link to somebody who shouldn't get it, or if that link gets forwarded or gets out, having password protection gives you some protection. Now, John will tell you neither of those is completely foolproof. Somebody could hack the password, find the encryption key, but those are at least things you can do that will, for most people that might accidentally get the link, prevent them from getting in. So we as lawyers, financial professionals as well, need to be thinking about everything to do. I agree with everything John said about so many breaches are because of internal actors who are bought off or corrupt, but many others are also social engineering, these phishing attacks that you're probably seeing every day where somebody tells you that your account has been hacked and call this number or do this or that or click on this attachment. That lets Trojan horses into your system and people can steal information that way. People can target individuals with private information. And I can tell you, just from my own experience in some of these situations, I can't disclose the names because they're not public, but a lot of people have been fooled into sending money, massive amounts of money. Had a client who sent $10 million as a result of a fake request. So it goes beyond those kinds of protection and it goes into the kinds of training that you ought to make sure that everybody in your law firm and your clients have about to recognize those kinds of phishing attacks and social engineering attacks and to also protect data to the maximum extent possible. So with that, I will turn it back to Katie and open up for questions, I guess.
Thank you so much. So I would like to see if there's any questions from the audience. Yes, pop up to the microphone. Thank you. Yeah, I can repeat it.
I work for a company that aggregates. Oh,
there we go.
I work for a company that aggregates public records data, and one of the big questions, and we aggregate it from courts, Secretary of State's offices, bar associations, and one of the big questions we deal with is the separation of public records data and personal data, as a lot of those public records might have, stuff people consider personal info, like their name, their address, email, phone number. How do you see the future of regulations and laws treating the difference between public data, what we would consider public records data, and personal data?
Well, I'll take that first. A lot of states already do this. I'll give you an example because I obviously have been working with Arizona for a while now. One of the things Arizona does, and a number of states now do this, is that if you are an elected official or an appointed official at a certain level, or a police officer, for example, you can apply to the county that you live in to remove your deeds from the database so that you don't get somebody you just arrested, you don't get his posse finding out where you live and showing up at your house. The problem with this is that if you've ever created an LLC or a corporation or something else, you can just bypass the recorded deeds section and go to the Arizona Corporations Commission, look up that person, find the information they put on their application maybe 5 years ago, 10 years ago, and get the information anyway. So the problem isn't, I don't think, so much as to what we call public versus private. It's making it so that it isn't so easy to get in the first place. Public information does have to be available because the public needs it. But I'll give you one quick story about what I'm working on. The book I'm putting out next month, the end of next month, is called Report to the Governor, and it's based on a report I issued to Governor Greg Ducey in Arizona. I issued the report back in May, and there were about 30 different areas of breaches and criminal activity that I could point to. One of the areas was in this area of public information and what it should be and what it shouldn't be. In investigating racketeering there, one of the things I've discovered was a racketeering scheme moving money laundering, moving billions of dollars literally through phony trust deeds. And in confronting one of the players in this scheme, they didn't know that you could find every single deed ever recorded in almost every county, but certainly in Maricopa County, going back to 1972 on the database. She had no idea. You know, she was older, didn't know from databases very well, didn't know from computers very well. And the sheer look of terror on her face when she realized I didn't have to actually go down to the county recorder's office to find document after document after document, but could sit at home on a computer and call every document up, compare every single signature, compare every single notarization. I mean, I thought she was going to pass out. Part of the problem is that you want people to be able to get information easily. But the problem has been on the other end is that what states and counties and localities have done is make it so easy to do it as a time saver that they don't realize what the data can be used for. So before you even get to what should be public and what should be private, you have to look at what should this data be used for. If we make every deed since 1972 available online, why are we doing this? It's great for someone like me who's investigating a case. I mean, this makes my job a whole lot easier. But why would we want to do that? What's the point of doing that? One of the things you can do is you can put cutoffs into the system. So you can only look at 5 documents a day. You can get around that, and there's ways to go down, say, to the county recorder's office and do it there, where you have to register. But I can look at thousands of documents a day without anybody knowing I've done it. And if I want to put together a fraud, I've got a whole lot of your information. And then, you know, one of the things that happens nowadays with subpoena power is that if you're a lawyer, if you're someone like me who builds cases and actually goes to trial, one of the things I can do is I can subpoena records from somebody. So I can find the first set of records in the recorder's office, and then after that, subpoena records, you know, from banks and other institutions without you even knowing it. And if I'm, as I said before, we have phantom lawyers. If you have a phantom lawyer, somebody who can't really be found and can't be caught, then that's what they're going to do. So one of the things to do is to determine not just what is public information, but what does the public need to do with the information, and not allow more information out than what realistically any person in the public really needs to see. You know, APN numbers, you know, parcel numbers and things like that are fine. But past that, we have to be very careful about what we consider to be efficient at the cost of privacy.
I'll just add to that I think this is a huge issue in the US with court records. Most court records are public, and there's lots of cases out there that are embarrassing, personal cases about people's divorces or other matters, and big company matters. I'm involved in several right now for pharmaceutical companies where they have massive filings in the cases, and the general default rule is that all filings are public access. You can try to file things under seal. Many courts are resistant to that. I think we need to change the rules and change the mentality to pretty much the opposite, that court records ought to be private unless somebody has a reason for them. And in that case, records can be released in a redacted form to redact out personally embarrassing information that's not relevant. So I think we need to strike the balance a little bit differently there. I would also say that the discovery is too broad, because even if you're protecting your client data, we face a lot of plaintiffs' law firms that might be small firms, mom and pop shops. We have to turn over data to them. They don't have the same size IT department as my pharmaceutical client protecting their data. And in the last year, I'm aware of multiple law firms and eDiscovery companies whose data has been breached. And so sensitive data has gotten out there. One final point is one of the big issues in eDiscovery right now with work from home, remote work, et cetera. A lot of people are doing work from personal devices, personal phones. You have the whole BYOD thing. And then the question is, well, what happens when you get into discovery and the work stuff is mixed up with the personal stuff? There's no easy way to search a cell phone and only look for the business stuff if people are mixing their business emails and personal emails, or business text and personal text. So how do you protect that? And if you are using your personal devices for company business, then you are at risk of having to turn over all the information, at least to be filtered to look for the good, to look for the relevant stuff. You might have to turn it all over in Discovery. So I think those are all concerns we've got to be aware of, and I think we ought to be shifting the pendulum back a little bit to greater concern and protection for privacy, more like the rest of the world and less like the wide open, the Wild West that we have in the U.S. I think somebody said that U.S. citizens care deeply about their privacy interests until somebody offers them a $5 Starbucks gift card to give up all of their personal information. So we need to take our personal privacy a little bit more seriously.
Yeah, I'll add one more thing to that. With court systems, because I've had to deal with this now for years, California, for example, used to be, especially in family court, you could seal records pretty easily. All you had to do is if both parties stipulated to it, the court would seal the record, which means you couldn't see the judgment, you couldn't see the bank accounts, you couldn't see the assets, you couldn't see the liabilities unless you were one of the parties. That's gone out the window, partly because of the press. The Freedom of Information Act and press requests have been such that the laws in most states now, including California, have changed. Everything is open, and it is almost impossible for both parties need to stipulate if you're going to get any kind of privacy protection over any kind of a case. Secondly, then the judge has to weigh that against the right of the public to know. So it's not automatic, and most requests are rejected. So don't think that once you get into litigation, this is going to be a problem. Certainly on a plaintiff side, it's going to be because the defendant is going to try to find everything they can about you. But even on the defendant side, because that's what the plaintiff is suing you over, something you probably did to which they want data.
Yeah, I would just add as well, why stop at call records and why stop at state records? Because technically you can get everything online as well, right? You just do a Google search. Maybe you can go on social media, you can go on a Facebook page, you can get pictures and so forth. And you can also go on LinkedIn, you can get their professional and educational information on LinkedIn and so forth. And, many times clients are asking, well, we can get all this information out there. Can we augment our database and use what's available out there? The reality is that you have to take into account the privacy laws as well. You have, for example, a GDPR, Article 14 of the GDPR, which do require that you provide information as well if you get information relating to a data subject from someone other than a data subject. So you do have notification requirements as well under the GDPR if you do that. And then, beyond GDPR requirements as well, you do have cases which came up in relation to data scraping. There has been the LinkedIn cases as well in relation to data scraping, which you will need to consider as well. Data scraping is what some businesses do is that they would just collect data from LinkedIn and other online sources and then use that data because it's available out there, but then unfortunately you do have terms of service and other terms and conditions for those websites which do prohibit as well in certain usages of the data and so forth. So you have to be mindful of that.
And I have a follow-up question for all four of you. I think some of the national and state privacy laws that we're talking about with the CCPA, CPRA, the new laws coming out in Virginia and Connecticut with HIPAA, do any of those start to address any of the concerns that you're bringing up here, or do they fall short?
I think they fall short. First of all, a lot of it is the individual. As was just pointed out, the amount of information we make available about ourselves, and you not need to worry not only about yourselves, but about your kids. What are they posting? What are their privacy settings? Employers now regularly, before hiring new employees, check people's social media. And if your kids, or college or whatever, are sitting there with pictures of them drinking or partying wildly, that's not going to be good for their long-term future. So I think a lot of it starts there. But also these laws that we're talking about, they're limited, and some like HIPAA focuses on medical information. They have limited applicability. There's lots of exceptions. There's only a few states. You mentioned the possibility of federal legislation. It gets thrown around every year. It did again just a couple months ago. Didn't gain legs. I'm hoping that, yeah, we do get some kind of uniform law, because it would be a lot easier on companies than having to figure out the different laws of, a whole bunch of different states. So we may get there, but I think that is only part of the solution. I think there's a lot that we need to take control of in terms of protecting our data.
Well, I would say it more simply, is that how many of you have had the pop-up, we use cookies, do you accept our cookies? And almost invariably, you click yes, that's fine, you accept the cookies. So it's great that they're telling you that they're collecting your data in some way. And cookies are not exactly data collection in terms of theft and the problems we're talking about. But how many of you have ever said, no, I won't accept your cookies? Because then you oftentimes don't even get to use the program.
So I'll mention one other thing too with respect to HIPAA. There's an old saying that the law is observed most commonly in its breach. And I would say, in response to your question, social media and the proliferation of apps are two things that, in fairness, HIPAA or really almost no federal regulations could ever have anticipated. It's one of the reasons that I took a few hours to put together this list of apps and which ones arguably do comply with HIPAA and which ones clearly don't, because in my practice I see medical device companies that are supplying to hospitals that are clearly regulated at multiple stages of their activities by HIPAA, where their salespeople are using apps which are demonstrably not compliant with HIPAA at all.
And since you mentioned earlier about the potential federal law, which may or may not come around, so there has been a lot of debate surrounding a federal legislation for privacy. And while it's certainly a very good thing that this point is being discussed, at this stage it's unclear whether the bill will pass. There has been quite a number of opponents to these legislations, and as strange as it may seem, you have a number of privacy advocates which are actually against that piece of legislation, because the reason why they're against it is that this federal bill would also have preemption. It means that it would preempt the other state laws, so it would mean that the California law and the other state laws on privacy would no longer apply. And while it's great for simplification, the issue that those privacy advocates see is that it means that you would have one single standard. It may be harder to come by a common standard. It may mean that you may have to water down a bit the standard in order to make everyone happy. It may be a bit harder as well to update the legislation. And as a result, you do have, for example, even the California Privacy Protection Agency, which has been quite vocal in voicing their opposition to that legislation, because they are fine with a privacy legislation at the federal level, but then they don't want it to set a ceiling. They don't want it to limit what can be done at the California level. They want it to be the minimum standard applicable to everyone, but then they want to have the ability to go beyond that when necessary. And at this stage, at least, the draft legislation doesn't allow that. So that's why you have a number of opponents to that federal privacy bill.
Well, let me say one more thing about this, because we've talked a lot about medical. Most people don't know that when you go to a hospital these days, or even go to your doctor, once you leave, most of your records are not stored anymore at the doctor's office. Those days of seeing file cabinets with files sticking out and the names and the letters and stuff so somebody can find your file are dead. Most of your data, if you've been into a hospital recently, is stored at a third-party vendor carrier. It's so to speak, in the cloud, but that information is now off-site. And we have found in our investigations that a lot of that data gets taken, usually, again, by an inside job. So even if you're protected at the hospital level, your data 5 years from now, 10 years from now, is going to be sitting in a cloud available to anybody who wants to invade that cloud.
All right, well, we are 1 second away from the end of our time, so thank you very much, and I hope you enjoy the rest of the conference. Thank you to our esteemed panelists.